Bueno, buenas tardes. Ahora ya en serio. Que muchas gracias por venir esta tarde a esta sesión. Yo soy Mercedes Carmona, soy copresidenta de la sección de abogacía de empresas y desde hace muy poquito, así que hay muchos de vosotros que no nos conocemos todavía. Lo primero, daros las gracias por estar aquí, pero creo que también espero que a muchos de vosotros os tenga que dar las gracias por haber completado la encuesta que envió el ICAM a los miembros de la sección de abogacía de empresa para entender un poco, ¿no?, la realidad de la abogacía de empresa a día de hoy. Tenemos los resultados que se van a compartir en breve. Son unos resultados súper interesantes, tengo que deciros, ya me contaréis vosotros y ya comentaremos. Y a raíz de esos resultados, pues vamos a empezar a trabajar desde el ICAM pues, para satisfacer muchas de las demandas que habéis hecho y que hacemos al colegio en relación a para qué os puede ser de utilidad en la colegiación. Y ya tenemos muchas pistas de lo que nos habéis contado y vamos por el buen camino, seguro. Así que 1.000.000 de gracias. Bueno, y hoy estamos aquí con una sesión que yo creo que va a ser súper chula, patrocinada por Traducción Jurídica. Así que muchísimas gracias a Traducción Jurídica por patrocinar la sección de abogacía de empresa del ICAM. La sesión ya sabéis que va a ir sobre las diferencias, ¿no?, entre la nomenclatura del derecho español y del derecho anglosajón. La ponente va a ser Rebeca Jowers. Rebeca es doctora en Filología Hispánica por la Universidad Carlos III de Madrid y por la Universidad de Michigan y máster por la Universidad de Nueva York. Profesionalmente se ha dedicado a la traducción jurídica durante más de 40 años, labor que ha compaginado con la docencia como profesora de inglés jurídico durante 20 años en el máster de Asesoría Jurídica de Empresas en la Carlos III. Es autora de 2 obras de gran interés para juristas: Léxico temático de terminología jurídica español-inglés, editado por Tirán Lo Blanche, y Diccionario de términos y conceptos jurídicos español-inglés, también editado por Tirán Lo Blanche. Muchas gracias, Rebeca. Yo tengo un montón de preguntas, ya te he hecho algunas al principio, pero bueno, seguro que nos vas a dar mucha luz, que es verdad que a la hora de traducir, todavía aunque llevemos muchos años trabajando con documentos en inglés, hay veces que nos cuesta la propia vida traducir ciertas cosas. Y yo ya me despido de vosotros, pero antes dar también paso a Fernando Cuñado, que Fernando Cuñado es el CEO de Traducción Jurídica. Y gracias de nuevo, Fernando, por esta sesión. Aquí te dejo.
Gracias, Mercedes. Bueno, pues en primer lugar tenemos que darle las gracias al colegio que nos acoge aquí en su sede, en este magnífico salón de actos, aunque hoy veo que están de obras por ahí, entonces será más magnífico dentro de poco seguramente. Y también, por supuesto, la sección de abogacía de empresa con la que estamos colaborando y haciendo esta jornada. Muchas gracias, Mercedes, hoy que la estás representando también, por el esfuerzo que estáis haciendo para los abogados in-house, ¿no?, que tan olvidados están normalmente, pues, y que nosotros los conocemos bien a muchos de ellos porque son grandes clientes para nosotros. Así que nos hace mucha ilusión colaborar con el colegio y más con esta sección. Por supuesto, a todos los que habéis venido, ¿no?, que hoy tienen más mérito, si cabe, por el día tan feo que nos ha salido con la lluvia y los charcos, pero bueno, muchas gracias por venir. Para premiar vuestra asistencia ya os hemos comentado que os íbamos a enviar un PDF con un manual de contratos que hemos escrito Ruth y yo, que está por ahí, que es mi mujer y mi socia de la empresa, y que os enviaremos por email mañana. Solamente deciros que algunas personas que os habéis inscrito directamente en la página del ICAM tenéis que dejar vuestro email ahí fuera, porque entonces no lo tenemos y no os lo podemos mandar el PDF. Los que os habéis inscrito en nuestra propia página y habéis recibido varios correos nuestros, no hace falta que os escribáis en ninguna parte. Y bueno, ha comentado ya cómo va a ser la agenda, Mercedes. Estaremos hasta las 5. A las 5 haremos un pequeño descanso para tomar café, que os lo servirán ahí fuera, justo a la salida. Y luego continuamos hasta las 6, 6 y cuarto. Y no he dado las gracias a Rebeca, es lo que es la confianza, perdóname, pero estamos súper contentos de contar con Rebecca Jowers, que es una eminencia en este campo de los contratos, y como sabemos además que es especialmente interesante para todos los abogados, tanto de empresa como de despacho, pero especialmente los que ejercéis la abogacía dentro de una empresa, pues nos ha parecido muy, muy interesante traerla y que nos hable de los fundamentos de los contratos anglosajones, cómo se diferencian. Ella es estadounidense, pero lleva 40 años en Madrid, o sea que casi es más madrileña que estadounidense. Y si queréis hacerle preguntas, se la podéis hacer en ambos idiomas. Rebeca, todo tuyo.
Ay, que hablo español razonablemente bien. Tendrían que, bueno, si no lo hablara un poco mejor después de tantos años. Pero siempre he dado la docencia en inglés. En la Carlos III, mis alumnos todos abogados decían, nosotros queremos, es muy bonito saber algo del derecho comparado, pero nosotros tenemos que saber cómo explicar el derecho español en inglés a nuestros clientes de habla inglesa. Pueden ser ingleses americanos o pueden ser japoneses o suecos. Y entonces, esto es una presentación un poco introductoria, pero hay otros cursos también que tenemos donde entramos en contratos con más profundidad y cogemos cláusulas de esas horribles que todos habéis visto y los vamos descifrando y destripando un poco, ¿no? Pero esto es la introducción. Y lo voy a dar en inglés porque mis alumnos siempre me han dicho, mis abogados, clientes abogados de traducción, queremos oír esto en inglés y lo queremos ver proyectado porque hay que ver cómo se escribe en inglés esas cosas tan raras que se pronuncia de una manera tan rara en inglés. Entonces, esto está ya aquí. Okay, so we'll switch to English, if that's okay. Topics we'll be discussing. Basic contract terminology. Usually with this session, I give a bilingual glossary, and I have a website. It's RebeccaJowers.com. Luego lo pongo aquí. And that's been published already this week on that website. Maybe we could, the glossary, you could also send it along with the PDF. But there's a glossary bilingual glossary of all the terminology we'll be looking at today, already ready for you if you'd like to see it. We're going to look at some of with contract formation, step by step through the life of a contract, some basic contract formation or theory, contract terminology. This is the main part I think that would be of interest. The trampas, las pitfalls, that confuse Spanish speaking translators or lawyers because they're so strange when we compare it to Spanish contract law. Then beware, although the plain English movement and español jurídico claro, comprensible, no? We're working on this, but unfortunately the contracts we'll be looking at, you'll be exposed to, will not be in plain English. And so examples of what we should look out for, something about the structure of English language contracts, and then to the point that we have time, we'll look at 27 standard contract clauses. I was speaking to Mercedes before. Many of these contract clauses, if we have a contract between two Spanish parties of the contract, many of them are not even needed because we have a civil code. But since the poor English-speaking common law people do not have a civil code, there's so many things about a contract that can go wrong. And ultimately, we don't want a judge to decide, how we're going to interpret this contract. So we have to have some of these strange clauses. The glossary, as I said, will be provided, access at RebeccaJowers.com. This is my last blog entry. Also, this is a blog with over 300 entries about Spanish-English legal translation. So some of the entries there might be of interest to you. And then one thing we always need to remember before we go any further, a term often has more than one appropriate translation. And you may sometimes have to find a definitional translation. We're going to have to define some things. There's so many strange things in Spanish law that won't be understood. How many of you have had to explain what a procurador is, what he does, and why he charges the fees he does? Okay, so obviously there are sometimes definitional translations. There are a lot of explanations we'll have to do before we can go any further with our English-speaking clients. And there won't be a Spanish law concept for much of this. The step-by-step, the expressions in English concerning contract formation. This is very basic, but we have the same type of the step-by-step formation of contracts. An offer, the action or indication by one party called the offeror, that he's willing to enter into an agreement with another party, the offeree. If this is accepted, this will create a contract, a demonstration or manifestation of the intent to make a deal. And obviously this can be spoken. El contrato verbal, we call this an oral contract in English, written most often in legal transactions, or displayed. If you walk down the street and you see the menu out in front of a restaurant, that's an offer to feed you, no? That is displayed. Or a billboard that's selling you something, some type of consumer object. The offer to form a valid contract requires several definite terms. The parties must be persons with the capacity to contract. That is, they should be adults with the ability to understand what they're doing. A party may be a natural person, an individual, or a corporation, a legally incorporated group. So, who may not be a party to the contract? And as the saying in English law goes, the law protects children and incompetents. No, una persona incapacitada judicialmente, no? Obviously, this person cannot, someone who's an incapaz, no, cannot enter into a contract. We call this person an incompetent. No es lo mismo que incompetencia, no, de los in los tribunales. We don't want to call un juez incompetente. We don't want to call him incompetent. No, we won't get on his good side during this trial. So I also have a 2-hour presentation on false friends, legal false friends. The top 20 that a Spanish-speaking lawyer cannot afford to not know, no. And then some others that are fairly hard to figure out. But false friends are some of the most difficult and some of the first things we encounter. And obviously, here we're not, the incompetente aquí no es necesariamente un juez, no? The subject, el objeto de contrato, the subject of the offer must be definite and specific, and both parties must agree on what they're contracting. This is the mutuality requirement of contracts. There must be a meeting of the minds. And this strange expression, meeting of the minds, if we look into Spanish law, we see that we have the acuerdo de voluntades, the same type of concept. The parties have to agree about the same thing and on the same terms. And then the price or other consideration. Consideration is this contraprestación. We'll talk a little bit about that, more about that later. But the price or the consideration, the contraprestación, the something for something, the quid pro quo, must be definite and specific. We'll talk about that a little bit more later. Excuse me. And the time, the offeror specifies a length of time that the offer remains open. If no time is specified, the law implies a reasonable period of time, depending on circumstances. You will have seen this term reasonable used so many times in Anglo-American law, in common law, and sometimes it's up to a judge to decide what is reasonable. And then obviously an acceptance in a written contract, the offeree accepts the offeror by signing it. Sitting down in a restaurant is acceptance of the offer. And performance, el cumplimiento, can also be a form of acceptance. If I see a poster on the side of the road that says, "Lost dog, I'm desperate, I've lost my dog. I'll give you $100 reward if you bring my dog." I don't knock on the door and say, "I would like to sign a contract to find your dog." No, I find the dog and I knock on the door and I say, "Here he is, $100, please." No, and this is acceptance. No, aceptación de la oferta por cumplimiento. Obviously, an offer can be rejected. It may be rejected outright, an absolute rejection. "Sorry, I'm just not interested." And then many times, especially in legal transactions, there'll be a counteroffer. The offeree may decide to make a counteroffer, rejecting the original offer and with a simultaneous substitute offer. And then consideration. We say that there's so many words, common words, consideration. Please take this into consideration. A simple everyday English word that we have a special legal meaning for this term. Something of value can be a promise, can be performance, can be actually cumplimiento, something exchanged that is needed to make an instrument binding on the contracting parties. A promise of performance without the exchange of something of value is not a contract. There must be a quid pro quo, this something for something, exchange between the parties in order for there to be a valid contract under Anglo-American law. This is obviously not the case in Spanish law, where you can have a gratuitous contract. We have a contrato de donación in Spanish law, but a donation called a gift in English, American, Anglo-American law must be done in a single party document called a deed, because it's not a contract. One of the idiosyncrasies of Anglo-American law. Performance, another one of those words. You know, a performance, I saw a performance of the Rolling Stones. This is not the same meaning, obviously. Putting into effect what the contract specifies, the fulfillment or completion of a duty under the contract. In Spanish, cumplimiento contractual, or sometimes ejecución del contrato. Ojo, obviously, you've all seen this 100 times. The term execution in English, generally, there are two exceptions, but okay, I won't go into that now. Execution 9 times out of 10 means to formalize, to sign the document and date the document. You execute the contract is now in force. And then a contract that has all of these requisites is enforceable. I think in Spanish law, we talk about a contrato válido or eficaz. No, we talk about it being enforceable in English. And its simplest definition is an agreement between 2 or more parties. Each party makes a promise that if breached, okay, if there is an incumplimiento, it is enforceable in a court of law. A judge will enforce it, will make the non-complying party comply. Some contracts may not be enforceable. A void contract, contrato nulo, though it may have the required elements, this contract may not be enforceable. If, for an example, it's agreement to do an illegal act, you can't sign a contract for someone to deliver a kilo of hash to you. No, that's probably not legal. We say it was null and void ab initio, nulo de pleno derecho. Sometimes we see null and void from inception. It's another synonym for this. And then there can be an avoidable contract, un contrato anulable. Examples, a contract with a minor, a contract that is grossly unfair with for one of the parties, sometimes in English called an unconscionable contract, un contrato leonino, quizás podemos llamarlo así. One made unintentionally, or one made by misrepresentation, fraud, or duress. And then breach of contract, sometimes called contract default, el incumplimiento, a party's failure to carry out the terms of the contract. Wrongful non-performance, and we use the term wrongful here, tiene que haber algo de dolo, no? Because if it's force majeure, the party maybe wanted to fulfill the contract and couldn't. So not wrongful non-performance of any contractual duty of immediate performance. Failing to perform acts promised by hindering or preventing performance, or by repudiating the duty to perform. And obviously there may be mutual breach on the part of both parties. And then what if we have a breach of contract? We have remedies. And this term is very difficult to translate. Lately I've seen it called remedios, but doesn't really do it, no. Spanish lawyers use remedios. Why? Because they all know what they're talking about already, no? But if you're talking to somebody that doesn't know what they're talking about, then remedios maybe will not be the right answer, the right translation. Here, if we're talking about breach, perhaps medidas resarcitorias del incumplimiento will work. Measures to compensate the non-breaching party for damages suffered due to non-performance by the breaching party, la parte no cumplidora. What are some of these most common remedies? The most common, obviously, is compensation for damages, un tipo de indemnización de daños y perjuicios. A court orders the breaching party to pay the non-breaching party damages, a monetary compensation. A court can order rescission and restitution. The court rescinds, cancels, terminates the contract, and orders the party to return to their situation before the contract was signed, their status quo ante. Sometimes this is very difficult. You're supposed to deliver the goods the supplier has supplied are supposed to be returned to the supplier. The money paid is supposed to be paid. What if the goods have been manufactured into a product? So rescission and restitution can be very complicated, as you all know. Specific performance. A court orders the breaching party to perform the contract in its exact terms. Okay? I don't want a monetary compensation. I want you to comply with the terms of the contract, and then this will be the judge who will order specific performance. Turning now to pitfalls. I don't know if there's a question about any of this first part. Basically, this is, yes. Mm-hmm. No, the contract was executed yesterday, means the contract was signed yesterday. Yes, of course. The normal standard translation would be, it was signed. I see though it was entered into, you can use that term also. The contract was entered into yesterday. The contract was signed yesterday. The contract was executed yesterday. And sometimes el ejemplar para firmar is called the execution contract, the copy for copia para la firma, okay? Yes, yes. Some parties can come to an agreement to accept an alternative performance. Yes, that's another possibility, obviously. Sometimes less. Sometimes one of the parties will realize maybe the other party is close to bankruptcy. Look, take the money and run. No, I'll take what I can get. And so they negotiate new terms for the contract. Okay. Any other questions about this first part? Pitfalls, some of the trampas, contract terms with special legal meanings. The first thing we see is agreement. No, you look at the document and you say, oh, this is more than an acuerdo. No, in the context of contract law, the term agreement is not merely an acuerdo, but rather is generally a synonym for contract. And this is used perhaps more often than contract. An employment agreement, contrato laboral, rental agreement, contrato de alquiler, franchise agreement, a contrato de franquicia, a license agreement for a trademark, for example, to use a trademark, contrato de licencia de uso. All of these will be called an agreement, but obviously are much more than an acuerdo. These are contracts. The term gifts, we talked about this earlier. Donación, the voluntary transfer of property to another person without compensation. This is not considered a contract under Anglo-American law. Also, strangely enough, it's not called a donation, it's called a gift, but the parties to a gift in English are the donor, the donante, and the donee, the donatario. And obviously, we don't want to confuse this with the term donation in English, which I think is donativo in Spanish. We could make a donation to the Red Cross or to Caritas, but if we're going to have a contrato de donación, this is a gift, and it will be made in a deed. Again, performance, el cumplimiento contractual. This refers to fulfilling or complying with the terms and conditions of a contract. Obviously, if this is performance, then non-performance, incumplimiento contractual. And there are lots of different ways of saying this. Obviously, there are many ways of saying a lot of things in legal terminology. So non-performance is also breach of contract, contract default, failure to perform, failure to fulfill or comply with the terms of the contract. All of these are synonyms of what we usually call breach. Another term with special legal meaning we've just mentioned, execution, generally with few exceptions, refers to signing and otherwise formalizing a contract. This contract is executed, is being signed in duplicate counterparts, en dos ejemplares, se dice en dos ejemplares a un solo efecto. It's the typical expression we see in a Spanish contract. If you're interested in knowing the one or two exceptions, or the one exception, if we're talking about an executory contract, if we use the term executory, then we're talking about a contract that is in the course of being fulfilled, en curso de cumplimiento, o a punto de cumplir. Once the executory contract has been fulfilled, then it's called an executed contract. But this is used so seldomly that we can think they executed the contract, they signed the contract. Okay? And as we mentioned, ejecución de contrato is generally synonymous with cumplimiento contractual, meaning performance of the contract, fulfilling or complying with the terms and conditions of the contract. Material, Madonna, the material girl. No? Maybe you're too young to know who Madonna is. You know? That's my generation. But the term material, when we talk about Madonna, the material girl, that's a normal English expression or term, and it has a special legal meaning, material in legal context. Material means significant, relevant, essential. Material breach of contract and incumplimiento grave may enable the non-breaching party, sometimes called the injured or the aggrieved party, to terminate the contract, depending on the terms of the contract. If I have a contract with a tailor to deliver my wedding dress, the wedding is on Saturday, and the dress is not delivered until Monday. No, hopefully in the contract it says that, no, this is an essential clause, time is of the essence, and not delivering the dress on time, I had to get married in my pajamas. No, this is a material breach of contract, and I at least can terminate the contract and get some type of, hopefully have some liquidated damages now already written into the contract. The term and then the term terms, no? Term generally, not always, refers to the period of time, the duration that a contract will be in force. This contract is for a definite term. And then terms or stipulations, stipulaciones, condiciones, the conditions or stipulations provided for in a contract, los compromisos, the undertakings, no? Under the terms of this contract, Party A has the right to use Party B's logos and trademarks. So term and terms sometimes are confused not by lawyers, just by translators. Before I learned some of this stuff, I was a budding translator. I had to learn a lot of this stuff the hard way, okay? So now we have damage and damages. Damage, daño, synonymous with injury. His car was badly damaged in the accident. I wasn't injured, but my car was badly damaged. But then damages, no, with this S at the end, many times daños y perjuicios, maybe you can translate this way. Money paid to a party in a civil suit as reparation for the loss or injury for which another person is liable. Based on the injuries sustained in the accident, the court awarded the plaintiff $60,000 in damages. More pitfalls. Contract terms with special legal meanings. This is not in all contracts, but this has come up in translation many times. Infant is not my baby. I'm not talking about my baby. Un menor de edad. In contracts and other legal documents, infant rarely refers to babies. A synonym of minor, a person under legal age, under 18, who has not reached the age of majority, la mayoría de edad. And British English has adopted child for this meaning. In British English legal documents, a person under 18 is a child. And obviously in this context, infancy denotes minoría de edad and nothing to do with babyhood, no, the fact of being a baby. We've all seen this, verb tenses. Passing on to this area, contracts aren't always drafted in plain English. Verb tenses, you'll see the term shall. Traditional contract drafting. The problem is we don't always draft contracts like we should. We're not always paying attention. But in traditional correct contract drafting, shall is not used to express a future tense, but rather to establish an obligation. Shall means has a duty to. And this is the deberá of Spanish contracts. For the sake of clarity and thinking we can't trust lawyers to draft contracts carefully, no, sometimes for the sake of clarity, many lawyers prefer must and avoid using shall confusing shall with this future contingency. Will is a little, well, they're obviously using it with that meaning, but I think it has less force than must. No, the deberá is must, obviously. But yes, I've seen that. I've seen the shall change to will.
If in doubt, shall.
No, yeah.
As the lawyers do.
Yeah. Okay. And then with may, in traditional contract drafting, may does not express a future possibility, what may happen in the future, but rather permission or authority, what the parties are allowed to do under the contract. And this is the podrá that you would see in a Spanish contract. Las partes podrán hacer tal y cual. Sometimes along with this may, you'll see is entitled to, indicates what a party has the right to, but may also, these shall and may in contracts are open to misinterpretation many times, and sometimes are used both with a future and a future possibility in the contract, and it's confusing. So perhaps adopting what modern contract drafters do and use must and is entitled to, or possible exchanges here to avoid this confusion. The here and there compound words. Everyone says we don't need these, don't ever use them. This is not plain English. You're a bad drafter if you use these. But I'm a bad legal English teacher if I don't teach my students or I don't mention these to you, because they're everywhere. What? Why? Maybe they sound cool. I don't know why. They don't mean anything. They're not necessary, but they're in contracts. And I was told, you know, don't teach your students this. This is not modern. And I said, they're going to go back and they're going to say, Becky, you didn't teach us half the stuff you should have. Okay, so the conditions contained herein. Is there a way to do this? You can slash out the here or there, look at the preposition, and look and see what the preposition refers to. That's the only truco, if there is one. The conditions contained herein, take out the here, this in, the conditions contained in this contract. The list attached here to. The list attached to this agreement. The price paid, therefore, not therefore, therefore. The price paid for the goods, okay? And if you type therefore, Microsoft Word will change it to therefore, because Microsoft Word has never seen therefore, and is not a lawyer who's had to ever draft this and has ever said the price paid therefore. The term set forth herein under, or hereinafter, excuse me, the term set forth later in this document. Let's get rid of all of this. But it means later, it means here in this document, and herein after this moment in the document. Absurd, yes, but it's in every contract. Has anyone ever seen a contract? I know you've all worked with contracts in English that doesn't have any of this. No, no one. I was going to say enhorabuena, hallelujah. No, modern contract drafting is coming into the new generations, but you're obviously new generation for me at least. And no way. Okay, so I just had to mention this now because this it's everywhere. These redundant doublets or triplets or synonym strings, depending on how many of these we have. And these are also everywhere. These are archaic uses, but I don't know, they sound cool. They sound like you're really, I don't know, are contract drafters, lawyers, English American lawyers, are they paid by the word? Like translators sometimes are. I can't imagine why they use these things still, but they still do. And we have orders not to use them anymore, but if you don't expose people who are learning legal English, if they're not exposed to these things, then they're going to say, Becky, you just don't know what you're doing. So a contract is null and void. Nulo y nulo. Okay? That's what it means. El contrato es nulo y por si acaso no te enteraste la primera vez, es super nulo. Okay? El contrato es nulo. The agreement is in full force and effect. Okay? Este contrato está vigente, está requete vigente. Okay? The contracts agree and covenant. Las partes acuerdan. Okay? Covenant is a cool way of saying they agree to something. We covenant this. This is my last will and testament. This maybe has a historical reason because a will, I get them mixed up. I think will was for bienes inmuebles and a testament was for bienes muebles, o vice versa, no me acuerdo. So the will and testament had a reason way back when you made two wills. You made a will for your bienes inmuebles and a testament for your bienes muebles. But it doesn't make sense today except that it sounds really cool. And every will, which you call a will, not a testament, starts out with the term or this expression, this is my last will and testament. Estas son mis últimas voluntades. Yes.
Sometimes the reason of these tablets is because the first word is an Anglo-Saxon word, while the second word is an French origin word. Because of the legal English comes from the Normans, yes. And many French words were incorporated into the English language. They were considered as the legal or the administrative way, yes. The people talk in the court.
Yes, some of them are a Latin root word and a Germanic root word. We see that with null and void, no? That there may be historical reasons for this, but sometimes, you know, agree and covenant. I just think they're stringing it together to make it sound cool, or they're charging by the word. I don't know. Okay, and then this is something that struck me, and my student said, "Is this being prohibited or not?" And so I started looking for these and pointing these out to my students because, and I call them, I've never seen this in a textbook for legal English. I call them apparent prohibitions. If you read only half of the clause or half of the statement, you think what they're talking about is being prohibited, but then there's a proviso. There's an unless, except, without, and you see that, yes, we can do this. So I've given you 3 examples here. No amendment to this contract shall be applicable. If I stop there, hey, the contract cannot be changed, cannot be modified. That's absurd. There's no party who wants a contract that is not capable of being amended, because if some circumstances change, we don't want to throw the contract out. We want to renegotiate whatever and make it work. The parties really normally want a contract to work. So no amendment to this contract shall be applicable unless, a menos, no, agreed in writing by the seller. There is an apparent prohibition. If we don't read far enough, it looks like it's being prohibited. But hey, no, it's allowed. The contract between buyer and seller shall not be assigned. No hay la posibilidad de ceder el contrato. Prohibida la cesión. No, without the prior written consent of the seller. If the seller gives his consent, the contract can be assigned. Neither party may assign or transfer this agreement without the prior written consent of the other. So both parties need to be in agreement. But if we say neither party may assign or transfer the agreement and we stop there, it looks like it's prohibited. Okay, have any of you ever looked at this or thought this was weird? Instead of saying no amendment to this contract shall be applicable unless, why not say? When the parties, when agreed by the parties in writing, or agreed in writing by the seller, any amendment to this contract shall be allowed. No, I don't know, maybe contract drafters are negative, no amendment. This shall not be done, neither party, okay? I don't know why, but this comes up over and over in contracts. And then a run-on clauses, okay? No punctuation. Well, this one at least has commas all over the place, you know. What can we do with this? No hay quien entienda esto. Party A agrees to hold harmless and indemnify and defend Party B, its officers, employees, agents, representatives, and successors in interest against any and all loss, damage, cost, or expenses which Party B, its officers, employees, agents, representatives, and successors in interest may incur or be required to pay by reason of any injury or property damage caused or incurred by Party A, its employees, subcontractors, or agents in the performance of this contract. How many of you have seen this? Dozens of times. Okay, they're paid by the word. That's the only explanation I have. Okay, so
there was a question. There was a question over there, or just
no, he was just saying yes. And you've worked with this, so this is no problem. But my younger, very young Spanish lawyer, recién graduados, lawyers see this and they say, Becky, what do we do with this? So this is what you do with it. How to attack a run-on clause? Eliminate the extra stuff. Party A agrees to hold harmless Party B against any and all loss which Party B may incur by reason of any injury caused by Party A in the performance of this contract. Okay, once we get rid of all this extra stuff and we understand what's going on, hopefully we understand what's going on at the end there, then we can add it all back in and it sort of makes sense, or it starts to make sense, no? But anyway, I had to include this because many of my students look at this and say what? And then archaic terms, you've come against these, I'm sure, come up against these. Archaic terms that are not used in modern English, but are in contracts for some reason, still sticking around. The term deem is simply a fancy word for considered. The clause was deemed irrelevant. The clause was considered irrelevant. construe. This agreement shall be construed, shall be interpreted according to English law. I've been told and tried to read and understand that there's a little difference between interpreting a contract and construing a contract. Haven't been able to figure this out yet. I'm still working on it in my old age. The letter and the spirit, yeah, okay, maybe. Maybe I'll look at that. You're probably right. But for our purposes, when you see construe, you can think interpreted, and I think it will work. But ojo, here also, the term construction. Construction of the contract, we're not building anything. No, we're talking about the interpretation. The term construction, we may be talking about interpretation. So, hey, thanks, I'll check that out. Avoid, the court avoided the non-competition provision. Doesn't mean the judge got sick of all the paperwork and avoided reading this. No, went home and had some whiskey and said, I'll look at this tomorrow. No, the court avoided the non-competition agreement. No, voided. No, anuló. Okay, so ojo, this is a tricky one. To avoid something, this is archaic usage, but the contract was avoided. The contract was voided. Okay, lo ha declarado nulo. And then determine. This contract shall determine on the expiration date. Determine on the expiration date. We know if the term expiration date is in capital letters, we can go to the definitions part of the clause and find out when that date is. But the contract shall determine, the contract shall terminate on the expiration date. Okay, these last two are very archaic, seldomly used, but can be fairly tricky. Yes, the meaning of determine. You can talk about a determinable obligation, an obligation that will terminate on a certain event, on the occurrence of a certain event. The term determinable is used with the meaning of capable of being terminated.
I guess sometimes it's used in the way of calculating things, to calculate the compensation or
Yeah,
something.
that's the modern meaning. I'm going to determine how much you owe me in damages. I'm going to calculate it. If you want examples, write to me. I'll give you at the end here. Yes, traductorjurídico@gmail.com, no? And I'll be glad to give you bunches of examples. This is archaic usage, but you'll come up against this sometime. You'll find this. Okay. This failure to fail to, sometimes I've been asked, what does this actually do? To fail to do something is just not to do it. Failure to do something, no poder hacerlo. So failure to perform is a synonym of non-performance, incumplimiento. Failure to comply, also non-compliance. In non-appearance, incomparecencia. Failure to pay, non-payment, impago. For some reason, these terms always translate into Spanish with in or im. But this failure to, fail to, sometimes you see this in contracts, and it just means not being able to do whatever the party was supposed. And I still make mistakes. Should not do it, but I still make mistakes with por y para. This takes English speakers a long time to figure out. And since it doesn't make sense to us, frankly, we still make mistakes. So parties to a contract, to enter into an agreement. A contract is binding on or perhaps more formal, upon the parties. The parties are bound by a contract. The agreement entered into force. These are things that perhaps you just sort of have to learn to see how they're used, because sometimes they do not match up with the Spanish preposition. Okay, and I think this would
We
be,
can have the break here if you don't mind.
take a break here. Is there a question or something we should look at?
Compartir con mi compañero, porque esto lo tengo todo el día en la cabeza. Todos estos problemas a los que una empresa puede enfrentarse si utiliza mal o traduce mal los términos de un contrato. Entonces, nosotros, no sé, yo comparto, cada vez en legal vamos siendo menos responsables de las plantillas, ¿no? De los contratos. Y está bien, porque tenemos que hacer que nuestros comerciales, nuestras funciones sean responsables de sus contratos y de todo. Muchas veces las plantillas no vienen dadas desde nuestras matrices. Y te viene la plantilla en inglés y el negocio tiene que coger ese contrato y traducirlo al español para utilizarlo. Y la mayoría de las veces, y repito, está bien, está muy bien, porque nosotros estamos para muchas otras cosas, lo hace el negocio por sus propios medios. En mi empresa, por ejemplo, estaba el plan A y el plan B. Yo no sé qué era peor. El plan A era Google Translate, pero tal cual.
No, the lawyer is many times the translator. The lawyer is the translator.
Y el plan B estaba fenomenal, pero era utilizar a una agencia de traducción cualquiera. O sea, lo mismo te traduzco un documento científico que te traduzco un contrato. Y aún así, el plan B tampoco funciona, ¿eh? Porque he visto cada contrato traducido por una agencia de traducción, pero no especialista en documentos legales. Entonces, yo ya lo que hago es, no voy a coger yo el contrato, no lo voy a traducir yo, no me voy a encargar yo, pero en esta casa se va a hacer bien. Y solamente se va a poder hacer con empresas de traducción especializadas en esto. Porque ya, es que son dos cosas para mí, ¿eh? Y las dos son importantes. Una es que puedes estar vinculándote en algo que no es lo que tú quieres. Y otra es la reputación también de la empresa, ¿no? Que cuando la otra parte vea el contrato, me están contando, es que yo he visto en mi casa, he visto contratos traducidos y dices que yo no entiendo. Si yo no lo entiendo, ¿cómo lo va a entender el pobre farmacéutico?
Ahora ya nos tienes a nosotros, Mercedes.
Muy importante que seamos conscientes en las empresas de la cantidad de chorradas, cuando menos chorradas, o problemas muy gordos en los que nos podemos meter por hacer mal una traducción.
Hilo de eso, sí que es cierto que, bueno, nosotros que tenemos nuestra empresa de traducción jurídica lo vemos todos los días. Lo que comentas de las agencias de traducción, muchas ocasiones lo que pasa es que una agencia de traducción busca un traductor, el que sea, que en un tiempo, el que sea, le saque una traducción, pero ese traductor hace medicina, marketing, publicidad, no puede hacer jurídica bien. Es nuestra opinión. Nosotros, bueno, hemos estudiado Derecho los dos y cuando nos llegan currículum para que les cojamos, muchas veces les decimos, o sea, lo último que tenéis que hacer es decir que traducís todas esas áreas, porque lo único que demostráis es que no sabéis de ninguna. Tú no puedes estar actualizado en todas las materias del derecho, de la medicina. Entonces eso pasa mucho en las agencias de traducción, es verdad, que necesitan sacar una traducción y cuentan de la gente que tienen, además, al menor precio posible también. Y también muchas veces hemos rehecho traducciones que nos han pedido porque la empresa se ha arrepentido, porque han tenido más de un problema. Y al final está la reputación de la propia empresa porque dices, hay contratos, primero, muy confidenciales y muy sensibles, que cuando estás utilizando la inteligencia artificial eso queda en el vacío porque tú estás metiendo un montón de texto, que eso tú estás alimentando, digamos, más memorias de traducción, más todo, y tú estás, por mucho que taches un nombre, eso está ahí. No debería, eso es un tema bastante inquietante. Y bueno, pues por otro lado, el tema de no hacerlo profesionalmente, reputación de la empresa y posibles, bueno, pues problemas, ¿no? Entonces, me parece estupendo que lo comentes porque es verdad que hay mucho desconocimiento, ¿no? Me parece que, bueno, esto lo puede traducir cualquiera, tenemos Google y para nada. Cuando un traductor profesional que ha estudiado Derecho, pues entiende las cosas lógicamente como si fuera el alter ego del abogado que lo ha escrito.
Yeah, just last week I had a case in which I had to draft a very simple NDA. And one of the things that I take a lot into account is take all the unnecessary things, right? Taught by many other mentors I've had. So just take it all off. And I had to do it for a client. They wanted it was to be enforceable in the US. So they wanted it like a final review by a US lawyer. And when I passed it to the US lawyer, literally like substantially what changed was all that you showed that must be taken away. And actually the client felt more safe with all that. So it's something that, yeah, I think it's gonna take some time to change.
They want to cover every possible contingency. So, you know, the party and his agents and his employees and whatever. Every contingency has to be covered. Nothing can be left to the imagination because the imagination might eventually be a judge who decides.
So a question would be, can it really receive more protection if you make a more exhaustive list?
An Anglo-American lawyer thinks so. No, the Spanish lawyer may say some of these clauses, we don't need this, we've got a civil code, we already know this. Carlos Lasarte taught us this, Dit Picasso, look up the text, you know, we've got this under control. But the Anglo-American lawyer would get nervous if he doesn't see all these stuff.
Question I've always had is some Anglo-American contract that I've seen, I've always wondered why there are some specific clauses, particularly the most sensitive ones, that are all put in capital letters. And I've always wondered if it's because some case law requires it for some matter or.
I think that's shouting. It's like when you send an email or something or a text message and you put all capitals, you're shouting, you're saying this is important.
Sometimes it's a statute requirement. I mean, the laws of Delaware, the laws of some states require the drafters to mark certain parts of especially the disclaimers of liability. Some states force the lawyer to put it in capitals just to prevent, not to read them, to avoid the small print.
The counterpart is a consumer.
Exactly. That's it.
Well, I mean, everything we do, it says, do you accept the terms and conditions? And you say, check. How many of you have read the terms and conditions? You never do. So, I mean, they can have paragraphs where they're shouting out and you know, the law says, put it in capital letters. But if the consumer, as you say, it's a consumer contract, the consumer doesn't read it until it's too late. No, until he has defective merchandise and he wants to find out, oh yeah, what is the guarantee? Or when did the guarantee expires 2 days, 2 days before whatever the problem is, no? That's what happens. Okay, should we take a break?
There's a coffee out there. So and if any of you has not received our letters, our emails, bueno, anotaros allí para que os enviemos el PDF. Gracias. Estamos ya, todos los que somos, pues continuamos. Gracias.
Para seguir, looking at the structure of English language contracts, I don't think there's anything here that is new for any of you. You've all worked with contracts. I just have some examples of different ways of introducing a contract here. The simple plain English agreement made this 22nd day of March, 2024 by and between. The only thing I would point out here is this by and between, these redundant couplets. You would say either by or between. Both of them are not necessary. Obviously, this agreement made and entered into by and between, otra vez cobrando por palabra, is either made or entered into by or between party A having its principal place of business at such and such an address, and party B having its principal place of business at such and such address. And then one that's a little bit more detailed. Some of my translator friends have looked at Spanish contracts, and they say when the parties are identified, you have so much information that the only thing you don't know about these people is their shoe size. No, in English language contracts, we don't have all of the information, where the company was incorporated, which folio in the notarial archives this is located on, in case we want to make sure these people exist. I don't know why. All this information, it's very succinct in English. This agreement, effective on the date identified below, is between Party A, a corporation organized under the laws of Canada and having its offices at such and such an address, and Party B, a corporation organized under the laws of Canada, a wholly owned subsidiary of Party A and having its offices at such and such an address. This wholly owned subsidiary, obviously, this is a filial 100% participada. Party B is 100% participada por Party A. And then recitals, whereas clauses, this means considerando que or por cuanto, the preliminary statements providing introductory background information before the binding stipulations in a contract. And then usually a long contract will have definitions. These definitions set forth the meaning of the terms as they will be used later in the contract. Traditional contracts, we see the expression hereinafter referred to as, en adelante denominado, and in modern contracts, they just say such and such means or shall mean, to give it the little English contract feeling, such and such shall mean this. In the remainder of the document, the defined terms will usually appear in capital letters, italics, or quotation marks. And then there's always some type of transitional language between the recitals and the stipulations. Now, therefore, in consideration of the mutual covenants and agreements hereinafter set forth, licensor and licensee agree as follows. This was taken from a trademark license. Now, therefore, in consideration of the mutual promises herein contained, it is agreed as follows. Acknowledging the above recitals, the parties here to agree as follows. Or, plain English people, it is agreed as follows. Then, whatever we want to call these, the stipulations, agreements, clauses, conditions, the essential undertakings. The term undertaking can mean several different things in legal English, but in corporate law and in contract law, we're talking about the compromisos of a contract. The parties undertake to do such and such. Las partes se comprometen a. We'll always see this undertake with this expression. And then the signatures of the parties with some type of transitional language. In witness whereof, the parties hereto have caused this agreement to be executed as of the date set forth above. Something like, en testimonio de lo cual, las partes del presente contrato han procedido a su firma en la fecha arriba reseñada. And really, there's a little difference here that I really don't know how to express in Spanish. When it says the parties, it doesn't say the parties signed the contract. The parties have caused this contract to be signed, this agreement to be signed. That's when the parties are two different corporations, for example, and representatives sign in the name of the parties, which are entities. So these entities, these parties, cause their representatives to sign. There's a little bit of difference there that's really not expressed in the Spanish translation here. And then los anexos, they may be called schedules, attachments, exhibits, appendices, or sometimes annexes, especially in European contracts. That for a native speaker of English, I think annexes would be the last choice. And then to look at some of these standard clauses, there are a series of standard clauses, las cláusulas tipo, that appear over and over in English language contracts. If we can identify each one and understand their usual content, we will have half the battle toward deciphering translating these clauses correctly. And we talked about out in the coffee there that Spanish contracts traditionally just had a number. Each clause had a number, and you had to read it and decide what it was talking about before you could figure out the meaning. At least in English language contracts, we all have a title, and we know that these clauses have a standard content. Of course, we don't know if the lawyer who's drafted these is going to add something else. We don't know how convoluted the language of this lawyer who's going to draft this is. And if we're going to understand it readily, or we're going to have to sort of decipher this and analyze it to figure out what they're talking about. But at least we have a clue as to what the standard content is. And as I've mentioned, in contracts between Spanish parties, many of these clauses may not be necessary. That's why we have a civil code. Okay, so some basic ones. Obviously, the subject clause, the purpose clause, corresponds to the objeto, stating the motives prompting the parties to enter into the agreement. Definitions, we've seen this previously. And then a contract clause that my students always said, what is this about? Representations and warranties. And how do we translate this? Not representaciones, no, garantías y
Manifestaciones.
manifestaciones y garantías, or something like that. Declaraciones, yeah. Really doesn't have a translation because there's nothing sort of like this in Spanish contracts. What is this? It's a type of cláusula comodín. Okay, anything you want to set forth, anything the parties want to clarify and make sure that the other party understands. Usually this comes right after definitions, the representations and warranties. We want to get this out of the way. We want to make sure each party understands what we want to declare to the other one and what we guarantee we're going to be doing before we go any further. So I define this or describe this as a cláusula comodín, a clause in which the parties provide assurances to each other concerning any matters affecting the content of the agreement, such as, for example, the status of their businesses. We're both legally incorporated and can do business in this state. The corporate authority to enter into agreements. I represent my company and can enter into this agreement legally. The ownership of property and assets. What I'm selling you is really mine. Or other legal requisites. I have the licenses that we need to continue on with this transaction, etc. You would, yes, you could. Exactly. This would be in a recitals clause, perhaps in a Spanish contract. The same type of non-standard content. Okay. The term, we saw this before, specifies the duration of the contract. The term of this agreement shall commence on the date hereof and shall continue until terminated in accordance with its provisions. Termination specifies the circumstances under which an agreement may be terminated during the life of the contract. Es la resolución anticipada. No, not the termination that is provided as the termination date, but under what circumstances the parties could terminate before the term expires. This agreement will remain in effect unless terminated by client on 30 days prior written notice. In the event the client terminates the agreement, client will pay supplier all unpaid invoices up to the date of termination.
These ones where the contract and expiration in different sections of the agreement. So there was a huge debate because the contract was terminated by one of the parties and the other party was asking for the consideration.
Mhm.
And because in one section, the contract said, after the termination of the agreement, the party will be entitled to this consideration. The other party was defending it only happens at the termination of the agreement, not at the expiration of the agreement. So expiration can be for different causes or reasons, and termination is expressly stated what's termination of this agreement. So even
That was probably,
English.
yeah, that was probably a problem of bad drafting. Okay, expiration would be the term. The term expires on such and such a date. And then the termination clause, like in Spanish, should really be entitled early termination. When can we terminate this contract before the actual expiration of the term of the contract? But if the drafters mixed up termination and expiration, or used the term termination when they meant expiration, or vice versa, then that's probably where your problem came. Yeah. Okay. The indemnity and hold harmless clause, a clause in which one party agrees to indemnify and hold the other party harmless. What does this mean? I've seen this translated as mantener indemne. No, mantener libre de responsabilidad civil. No? To hold someone harmless or indemnify the party means to hold them not liable in the event of a lawsuit or claim by a third party relating to the subject of the agreement. Party A shall indemnify, defend, and hold harmless Party B from and against any claim arising out of or relating to Party A's actions, inactions, negligence, or negligence in the performing of its obligations under this agreement. Mm-hmm. There, they're used as synonyms in clauses. The idea is there is some type of claim or lawsuit from a third party. I can think of un contrato de edición. Tirant's going to publish my dictionary. Okay, and the contract, for example, could have a clause saying, I certify or I promise or whatever, I represent that I am the author and this is an original work. And then there'll be this indemnity to hold harmless. If Tirant is sued because someone says, you plagiarized me, okay, then I have to hold Tirant harmless and indemnify them, meaning the lawsuit's for me. Mm-hmm. Es que, depending. No, it doesn't. You're not guaranteeing that the person is not liable. You're guaranteeing that you assume the liability. Okay, the lawsuit is for one party, or the claim is against one party, because the other party is indemnified against any lawsuit or claim. No, it's.
I think you're thinking like a Spanish lawyer. Because English lawyers or English judges or American judges don't think that way. They just construe the business as it's written in the contract. So everything depends on what's written down in the contract. So there's no more arguing about this if responsabilidad solidaria or something like that. That's another problem, a big one,
No,
by the
well,
way.
if that's the case, then your English version has to say, in case of disagreement, in case of dispute between the parties, the Spanish contract shall prevail. Spanish law, well, the Spanish version of the contract, the original version. The translation is provided for information purposes only. That's what you see on the translation. For example, Spanish corporate documents. You go onto a Spanish corporation website, and the documents are there in English, but they start out saying English version for information purposes only. For any other whatever, consult the Spanish version.
May I say something about indemnifying? I've made a little bit of research about this, and as regards to his question about the difference between indemnify and harmless, I mean, the American lawyers, they don't agree between them. La doctrina no es pacífica. So imagine how difficult it is for us to understand this when they don't even agree if these concepts are just one or are different. I've read some lawyers, American lawyers, who says that there's a difference because indemnify applies, or indemnify applies when there's money damages to be adjudicated or awarded in some cases. And you only need to use harmless when there's no money damages. But others say that it's the same. So it's quite difficult to find if there's or not a real difference where the American lawyers, they do not agree. So it's a complicated matter. It's quite complex.
Yeah.
We need a civil code.
Most of the times are used interchangeably.
Okay. The provision for curing breach or default, la subsanación del incumplimiento, a clause providing the possibility of curing, meaning correcting or remedying a breach of contract within a specified term. Any breaching party shall have 30 days from the date of receipt of the written notification to cure such breach. And this subsanación, no, the idea is cure, sana sanita, no, you cure the breach, after which the aggrieved party may terminate this agreement or pursue an action in equity of law. And my lawyer friends always say, well, Becky, this is a dual clause, really, because it's a provision for curing the breach, but it also is an early termination. Hay una resolución anticipada, okay? But because if after the 30 days, the breach is not cured, no hay una subsanación del incumplimiento, then the aggrieved party can terminate the agreement, la resolución anticipada, and pursue an action in equity or law. So it's really a hybrid clause here. Liquidated damages. No, what do we call this? Because we don't have them. My Spanish lawyer friends immediately say, my lawyer students, oye, parece una cláusula penal esto, no? It looks like a cláusula penal, and it is a penalty clause. But since in many states, judges have ruled that penalty clauses are abusive, we have penalty clauses that we don't call penalty clauses. We call them liquidated damages. Here, liquidated means pre-calculated, predetermined. Liquidated damages, a clause stipulating in the contract a predetermined amount to be paid as damages in the event of a certain type of default. Okay, it looks like a cláusula penal, it acts like one, it's a penalty clause, but it's not entitled penalty clause. In the event of delay in the performance of Section 12 of this agreement, contractors shall pay liquidated damages to company in the amount of US dollars, and then there would be a sum here, as a genuine pre-estimate of the foreseeable damages incurred by company, whatever, to such delay. And sometimes the liquidated damages clause, I have collections of clauses, and there's one that says as liquidated damages and not as a penalty. As if that will help. No, in case a judge gets involved in looking at the clause and interpreting the clause. The entire agreement, a clause stating that the contract constitutes the entire agreement between the parties and is included to prevent one party from claiming that there were other previous oral or written agreements that should be considered part of the contract. I don't know if you need this in a Spanish contract, but you know, all of the things we discussed over dinner at such and such a restaurant and the 2 bottles of wine we consumed, no. Well, all that stuff that I promised you, no. Sometimes this is called a 4 corners clause. What is in the contract, in the written agreement, and none of the emails or the WhatsApps or whatever we pre-agreements we had are part of the contract. This agreement contains the full understanding of the parties with respect to the subject matter hereof and supersedes, prevalece sobre, supersedes any previous oral or written agreements between the parties regarding such subject matter. Amendment, obviously, provision expressly stating how any part of the agreement may be modified. I've never seen a contract that says this agreement may absolutely not be changed. The parties want the contract to work. But once again, this is one of these apparent prohibitions. This agreement may not be changed, modified, amended, or supplemented. If we stop there, can't touch it. Except in a written document signed by both parties. So obviously, a contract will always be amendable. Assignment, la cesión, clause indicating whether or not the rights and obligations under the contract may be transferred to another party, and if so, under what conditions. Neither party may assign, transfer, or sell its rights under this agreement, or delegate its duties hereunder without the other party's prior express written consent. Supposedly, you have rights in a contract. You can transfer rights, sign and transfer rights, but you delegate duties. Hablando con propiedad, no? You delegate duties and you assign rights. And so can you ever say no to assignment? The typical no to assignment would be in a labor contract, a labor agreement. Under no circumstances may employee assign his rights or delegate his duties under the contract. If I'm sick of working for this boss, I can't send in my cousin John, and John shows up and sits in my desk and says, yeah, no, John assigned the contract to me this weekend. No, it doesn't work like that. So obviously an assignment clause can say no, but the ones we've seen so far say yes under, as long as the parties agree in writing. Severance or severability. Severance, to sever, some of my students said, what does that mean? I had a terrible automobile accident and my arm was severed. I lost my arm. Okay, so sever means to cut off, cut out. And obviously, when we say a contract is severable, we're not going to cut out part of the contract physically, we're going to ignore it and try to make it work. A clause that determines how the parties will proceed to maintain the contract in force if part of the agreement is found to be illegal or unenforceable. And I think in a Spanish contract, perhaps this type of clause is called nulidad parcial. The contract is partially null and void, no? But we're going to try to make it work. If any provision of this agreement shall be prohibited by or judged by a court to be unlawful, void, or unenforceable, then such provision shall be severed from the agreement. We're going to not cut it out, we're going to ignore it. The remaining provisions and all other terms and conditions shall continue in full force and effect. Non-waiver. What happens if I have a supplier, I need the goods on the 5th of every month to start my work, and for the last 18 months, sometimes he's delivered on the 6th, on the 10th, on the 11th. Can't get him to deliver on time. After 18 months, he says, there's a precedent. I can deliver when I want to. And maybe a judge will say the contract has been amended. This is the non-waiver clause, fixes this. Just because I let you breach, I ignore your breach, continued breach, several breaches, doesn't mean I have waived my right to oblige you to comply with the contract in the future. A provision providing that if the non-breaching party ignores the other party's repeated breach, this does not set a precedent with respect to future breaches. That means the non-breaching party, la parte cumplidora, does not waive his right to demand future performance. The failure of either party to insist upon complete performance by the other party of any provision of this agreement shall not be construed as a waiver of the right to insist upon strict performance in the future. I don't know if this type of clause is necessary in a Spanish contract. Obviously, okay, so this is not perhaps standard, but the idea is if you have tolerated breach, it doesn't set a precedent. In the force majeure or acts of God clause, this always surprised my students. Acts of God, el Señor tiene la culpa. No puedo cumplir el contrato y el Señor tiene la culpa. Acts of God. A clause excusing non-performance in the face of events beyond the control of the parties. I think these concepts are sometimes equated with fuerza mayor y caso fortuito. I've seen this written. Neither party will be in default of its performance if performance is delayed or becomes impossible or impracticable by reason of any cause beyond the party's reasonable control. And is there a difference between acts of God and fuerza mayor, force majeure? We have lots of, as we have legal Latin in English, we have lots of legal French in English. The only thing is you can't pronounce it in good French because no Anglo-American lawyer is going to understand you. You have no fear that I'm going to pronounce it in good French, no? So you can sort of basically use my force majeure translation here. Acts of God strictly refers to natural disasters, including earthquakes, floods, tornadoes, etc. And force majeure includes natural disasters and acts of man that may hinder or prevent contract performance. Breakdown of machinery. No, we couldn't produce because the machines didn't work. Strikes, las huelgas, lockouts, el cierre patronal, boycotts, riots, civil unrest, acts of war. All of these are possible fuerza mayor, acts of fuerza mayor. Governing law, sometimes called applicable law, and especially in international contracts where there are laws of two different countries or states, sometimes choice of law. Indicates which state or which country's laws will be applied to interpret the contract in the event of discrepancies between the parties. Elección de derecho aplicable, I think, is perhaps one of the ways this type of clause would be identified in a Spanish contract. This agreement shall be governed by and construed and interpreted in accordance with the laws of the state of New York. Or the laws of England and Wales shall govern this contract and any dispute or claim arising out of it in connection with its subject matter or formation. And then the first cousin of the governing law clause, jurisdiction for court action or choice of forum, choice of venue, a clause that determines the court in which a lawsuit or action should be filed in the event the parties wish to take their disputes to court. I think this is called sumisión a fuero, perhaps. This agreement shall be governed by the laws of the state of Florida. For the resolution of any disputes arising with regard to the interpretation of this agreement, the parties hereby submit to the jurisdiction of the courts of Dade County, Florida. And this applicable law and jurisdiction or choice of forum venue clause usually comes together as this example usually is included in the same clause. Dispute resolution Alternative Dispute Resolution, ADR, a provision in which the parties agree to submit any dispute to a non-judicial form of dispute resolution, arbitration, mediation, conciliation, in order to reach an out-of-court settlement. Resolución de conflictos.
Más que métodos alternativos.
Sorry, that word makes me very nervous right now. That term is not one of my favorite terms lately. I'd never heard it called that. Don't call it that around me. Okay, yes, but yes, it's a possible, yeah, okay. Why would we do this? Maybe the judge, no, courts are slow. Courts are expensive. Going to court is expensive. Courts are not private. Maybe we don't want our shareholders to know about this dispute. There are a lot of different reasons that we would maybe take this to some type of alternative dispute resolution. Maybe the judge doesn't know enough about our conflict. We need some experts here, an expert arbitrator. A typical mediation clause would be, the parties agree that in the event any dispute arises pursuant to this agreement, which cannot be resolved by negotiation between the parties, they shall endeavor to agree the appointment of a third-party mediator to assist in the resolution of the matter. The cost of such person shall be shared equally between the parties. And then, of course, arbitration is the most common. In the event disputes are submitted to arbitration, this provision sets forth the procedures for choosing an arbitrator and the rules that will govern the proceedings. And I've seen this cláusula de arbitraje or cláusula arbitral, cláusula compromisoria, is that correct? Cláusula de sumisión a arbitraje, etc. Any dispute arising in connection with this agreement shall be finally settled in arbitration, conducted before a panel of 3 arbitrators in Los Angeles, California, in the English language, and according to the rules of the American Arbitration Association. This will be a standard clause. Independent contractors. What is the extent of our contract? Is this a joint venture? Are we partners? Okay, and this independent contractor's disclaimer of agency, I don't know if you would need this in a Spanish contract, because people may not, you have a civil code, so people may not read into the contract relationships that aren't really there. But this is used to preclude that one party says there is a relationship between us that is not really specified in the contract. It states that the contract is the only thing binding the parties, that they are independent contractors, and the agreement is not intended to create a joint venture, a partnership, an agency relationship between them, anything that is not actually specified in the contract. The parties to this agreement shall be deemed to be independent contractors, and nothing in this agreement shall be deemed to place them in a relationship of employer-employee, principal agent, partners, or joint venturers. A non-competition clause or a covenant not to compete, sometimes called a restrictive covenant, usually in an employment contract, and the employee agrees not to compete with his employer for a period of time in a given geographic area following the termination of his employment. And I've seen this as cláusula o pacto de no competencia. Question? Oh, how you move there. Okay, the employee agrees that he will not for himself or on behalf of another person engage in any business activity that competes with the company within a number of mile radius of the facility in which he was employed for a term of such and such years. This is another one of these clauses that American judges, American courts have said can be abusive. So the geographical area cannot be too limited, depending on the type of employment. I worked as a in-house translator for a perfume company. And a perfumer, someone that invents perfumes, can't get a job in a lot of places. So this would be a very specialized type of employment where you cannot limit the geographical area or limit the number of years this person can seek employment from the competition, because there are only four companies in all Europe where this person could work. Okay, courts sometimes in the States have ruled that this type of clause can be unfair, can be abusive. Confidentiality and trade secrets, the clause in which a party undertakes not to divulge, reveal, or disclose. Those are the typical terms you'll see. If you see any of these, you're probably going to say, oh yeah, a confidentiality or trade secrets clause. Not to divulge, reveal, or disclose information regarded as confidential or trade secrets, the cláusula de confidencialidad. Each party will keep in confidence the other party's confidential information, provided that the confidential information is not in the public domain. Okay, to be in the public domain, ser de dominio público, or has not been previously received from a third party not bound by a confidentiality agreement. Yeah, someone has already told me about this information. I saw it on internet. It's in the public domain. It's really not, I don't have the confidentiality obligation anymore. Limitation or disclaimer of liability. A clause that wants to limit. Sometimes it's a limitation of liability clause. Sometimes it's a disclaimer of liability clause. The idea, excluir responsabilidad. In many cases involving consumer goods, you cannot totally disclaim liability, but this is the idea, to limit or to disclaim the liability of one party to the other, or the liability of a manufacturer vis-a-vis consumers, the exclusión de responsabilidad. And this vis-a-vis is a preposition taken from the French, that we use in English, sort of formal English. Has nothing to do with the vis-a-vis in las prisiones en España. No, si estás en tercer grado y te han concedido un vis-a-vis, doesn't have anything to do with the vis-a-vis that we see here. No he estado en Soto, regaladito. Es una cosa que se sabe leyendo cosas de derecho penal y proceso penal. Audit of books and records. If I have a franchise, Telepizza, no, I need to know how many pizzas you've sold this month. Maybe I need some royalties from you. So the audit of books and records, a provision permitting one party to inspect and audit the records of another party. Records meaning accounting records, everything from the accounts to invoices to whatever. The term record here is very broad. And this is done warranted, maybe needed in a partnership, a joint venture, a franchise, etc. Party A shall be entitled at all reasonable times by its employees or agents to inspect the books, accounting books, of Party B relating to the rights granted in this agreement. Company A may exercise the right of audit and inspection of the books only once in each year during the term of this agreement. A notice provision, obviously, domicilio para notificaciones, every contract will need this, the provision indicating where and to whom a party should notify the other concerning any event that affects the contract. Any notice given under the provisions of this agreement shall be in writing and sent to the address of the party to be served, set out at the head of this agreement, or to such other address of which notice has been given. Timely performance, we talked about this with a couple of lawyers out in the coffee, or time is of the essence. And this, the clause, all it has to say is regarding all times and dates. Here it says both parties agree that all times, dates, and deadlines referred to in this agreement shall be of the essence. If it says time is of the essence, it converts any breach of these dates and times into a material breach. Included when timely compliance with the terms of the contract is essential, rendering any failure to perform a material breach of contract. Creo, plazos esenciales, se puede hablar así, llamarlo así. Lo he visto en algunos contratos españoles. Plazos vinculantes. Survival of obligations. A clause providing that certain obligations under the contract will survive, meaning continue in effect after the termination of the agreement. Usually confidential information, non-disclosure, this type of thing may be considered something that will survive the contract. I no longer work for this employer, but I cannot reveal his confidential information. Following the termination of this agreement, the provisions with respect to confidentiality, non-disclosure, and limited use of the product will survive. Okay, continuing in effect. The obligations of confidentiality set forth herein shall survive the termination or expiration of this agreement or any extension thereof. And then the last clause here, counterparts, a clause stating that the agreement is being signed in 2 or more identical documents, each of which is considered an original. The problem is in English, we don't have a word like ejemplares. No, if I say, give me a copy of your book, I'm probably asking for an ejemplar. But if I say, give me a copy of that article, I'm probably asking for a reproducción, una fotocopia. And both of these are copy. So we had to invent, for legal English, for contract English, we had to invent this copy, this counterpart. If 3 parties sign the contract, each party wants to think that this document is the original document. So it's a counterpart of the contract. Se firma en duplicado a un solo afecto. And that's expressed in Spanish with this expression. No? So each of the counterparts is considered to constitute one and the same document. Okay, and thank you. I had a lot of fun. I hope some of this was of interest of you. I know you're all experts already. When you've seen this, when Fernando said, why don't you give them this presentation? I said, I think they already know this. But anyway, we've survived this. There's no survival of obligations now to each other. And I appreciate this. If you have a comment or question or whatever, traductorjurídico@gmail.com. I have some cards here if you want more information. And then Rebecca Jowers, my name, .com. If you'd like to see 300 entries in a blog where I explain a lot of these complications of translating legal Spanish to English and legal English to Spanish that some of my lawyer clients have found interesting. Okay, thanks.
Tenemos tiempo para alguna preguntita, si queréis. Y bueno, pues si no, muchísimas gracias por venir. Gracias también, Rebeca, por esta exposición que nos has hecho tan brillante. Yo tengo mis notas, tengo aquí 2 folios con notas también, porque siempre...
Me vas a preguntar ahora.
Sí, hombre, desde luego, siempre se aprenden cosas. Y bueno, gracias también a los que nos estáis viendo en streaming, al colegio, por supuesto, a la sección de Abogacía de Empresas. Es un placer colaborar con vosotros. Esperamos que os haya servido. Os enviaremos nuestro regalito mañana a los que estáis aquí. Y cualquier cosa que necesitéis, por supuesto, estamos a vuestra disposición. Os recuerdo que tenéis también un 10% de descuento en nuestros servicios por el acuerdo con el que hemos llegado con el colegio. Y nada más. Mercedes.
La sesión, bueno, tampoco sé el nivel de los asistentes, espero que no se sepan todo. Ya te digo yo a ti que, bueno, yo soy de la Fallera, o sea que muchos años de trabajo y seguimos aprendiendo. Y ha habido muchas cosas que nos has contado. Ha habido muchas cosas que nos has contado que las llevamos, yo personalmente. Ya te contaré.
Vale.
Un millón de gracias y yo ya estoy pensando en siguientes sesiones, que tengo mucho que contar. Vámonos.
Gracias.
Y muchas gracias a todos.
Muchas gracias.